to preserve the integrity of the process and the hearing office by avoiding ex parte communications. So please just make sure to include everyone on the service list with any communications, which with email is pretty easy to do. Besides all of you, the only other parties on the service list are some representatives of the Bureau of Reclamation. And it doesn't look like the Bureau is going to be participating as a party, but please just include them on the service list, and then we won't have any issues about that. I wondered whether anyone else was going to show up. We did a public notice of these petitions and no one filed protests. We've done this notice of this pre-hearing conference and no one else has filed a notice of intent to appear. So it does not look like we're going to have any other parties, but we will see and certainly keep it open in case somebody asks to participate. So let me just go forward. This is probably going to be pretty quick today. I do appreciate you're preparing and filing the joint pre-hearing conference statement. It's quite informative and will make today's proceeding go a lot more efficiently. I did ask if we can call Trimont Land Company Trimont, and you said yes, so that will be easier. And then the pre-hearing conference issues, which were listed in the notice, were to discuss the hearing issues, discuss the pre-hearing and hearing schedules, discuss procedures, and any related issues. So I'll start with that. On pages 5 and 6 of the hearing notice, the hearing issues are listed. Does anyone have any comments? Are there any corrections, additions, edits that you think are appropriate to the hearing issues?
Mr. Lilly, as we said in our joint pre-hearing conference statement, I think we believe that the listing of issues was appropriate in the hearing notice.
Okay, thank you. The one thing I did notice, it's not a new issue, but a sub-issue, which will become more relevant as we move forward. I do think it's important that your papers and the proposed order my office prepares discuss the elements of its section 844 of the State Water Board's regulations is the elements for cause for granting extensions of time. And since there are petitions for extensions of time, it will be important to discuss the elements of that regulation. Okay, so let me go forward, and I'm going to jump forward to number 3, which is the applicable procedures, and then we can come back to the schedule. And as you know, I had proposed an earlier schedule and you asked for more time, and I did send you a letter. I wanted to let you know right away that I was amenable to more time. Mr. O'Brien, it's pretty hard for me to argue when you say you're busy because of another matter before my own office. So that was pretty convincing, and certainly Ms. Quincy appreciates that.
We appreciate your willingness to grant us additional time, Mr. Lilly.
Well, I can certainly assure you the Kings River proceeding is going to be a lot more complicated than this proceeding. Without saying more about it than that, I just from reading the papers that Ms. Quincy has prepared, I think that one's going to be a little more complicated, but we'll get through this one too. So let me just tell you what my thoughts are, and then I'll ask for your comments. No one, as I mentioned before, no one filed any protests to the petitions. And normally that would mean under the board's process, no hearing would be required. However, in this case, we have it was term 7 of the Water Board's decision 1342, which got carried forward to become term 10 of each permit. And it basically, I'm sure you're all familiar with it. It says no extensions of time beyond December 1, 1985 to complete application of the water to the proposed use shall be allowed without a hearing before the State Water Resources Control Board. And frankly, that's why the Division of Water Rights assigned this matter to my office to begin with. And I think with that, we need to have a hearing. Your pre-hearing conference suggested we could do that on the papers. Rather than argue about whether or not we need to have a hearing, it's easier just to have a hearing. But it can be, I will say, a very short hearing. But I think to satisfy that requirement, we should have a hearing. So here's what I propose that would be involved in the hearing. You would submit written proposed testimony and exhibits the way you normally do for water board hearings. But then during the hearing, there would be brief opening statements. The witnesses would take the oath and confirm that their written testimony is in fact their testimony. The witnesses would answer any questions from the hearing officer if we have any. No need for any summary of testimony or cross-examination. And then in lieu of submitting closing briefs or a closing brief, I propose that you prepare and submit a proposed order. I think it'll be a similar amount of work and for you, maybe less and maybe more a little bit, but it certainly will move our process forward because then my colleagues and I in this office can use that proposed order as a starting point for our proposed order that we ultimately prepare and send to the water board. And what we would do would be we would edit your proposed order and circulate it to you for your review and comments, and then prepare a final proposed order, which obviously has to go to the board for its consideration. In the meantime, my staff and I, mainly my staff, are preparing proposed amended permits. At this point, it's easiest just to prepare new, what we will call amended permits, but that will supersede the 4 existing water right permits. And there's really not much secret about what's going to go into them. It takes a little while because we have to make sure every detail is right. But although basically we'll use the existing permits as a starting point, there will be new deadlines for applying water to beneficial use, obviously, and then the changes to the points of diversion and places of use, purposes of use that you've requested in your petitions. And then also we do have to bring in the new standard permit terms that the board requires for all of its new permits. But we are preparing those. We will circulate those to you as soon as we can, hopefully before the hearing, so that you can comment on those as well during the hearing. And also so that then you can reference that in your proposed order. And if you're wondering about the format for all this, we have a proposed order on the Sacramento County Water Right Change Petitions, which we've posted to the AHO webpage, and you can see it in this. I mean, obviously there are different substantive provisions, but the overall format would be the same. That one, there's an order and appendices with proposed new, in that case, water right licenses, but here would be permits. But they're just appendices, and the order, if approved by the board, would simply direct the Division of Water Rights to issue the new, in that case, licenses, and in this case, permits. So I think that's a fairly efficient process going forward. It reduces the burden on the Division of Water Rights, which with this drought has a lot of burdens right now and would appreciate that. And it also gets things moving forward for all of you. So let me just check my notes. That's my plan for going forward. So I'll ask you whether any of you have any comments on that.
I would just comment, Mr. Lilly, that I think that plan makes a lot of sense. I like the idea of going straight to the proposed order and not doing post-hearing briefs. So I think that's a good plan. Okay, Mr. O'Connor or Mr. Taggart, anything to add?
Nothing to add, Mr. Lilly. We agree.
Okay, good. Well, we're all pretty darn busy, and we're going to get a lot busier in the next few months with the drought coming forward. So if we can reduce our workload in this hearing, I think it's in all of our interest, you know, of course, with respecting the requirements we have to follow. So with that in mind, and particularly if I were to ask you or direct you to submit the proposed order with your proposed written testimony and exhibits, and you know, and I don't want to convey the impression I want this to be lax. I think it is important that you submit sufficient documents so we have an adequate administrative record to support the board's ultimate order. Opposition or not, it's, as you all know, as good administrative law lawyers, we want to have a good administrative record here. So I'm counting on you to prepare and submit exhibits and testimony that are adequate to support the proposed order and to prepare the proposed order. And with that, what is a reasonable schedule for you to do all of that?
Mr. Lilly, as you know, we asked for a 60-day extension. If we went 60 days, that would mean a hearing on or about July 27th or 20th, sorry, and a deadline for submission of evidence of July 12th. Candidly, we are completing the CEQA process at NCSD, and it would be helpful to us if we could have a little more time, perhaps into the first week of August to get that CEQA process completed. If that's not possible, I think we could certainly accommodate earlier dates, but I guess our preference would be something in a hearing date in early August, and then a related deadline for exhibits. I think previously you had about an 8-day gap there, so if we could do something like that, that would work for us.
Okay. Yeah. Let me see. As you all know, I was a lawyer in private practice representing parties for about 30 years. So I do have some sympathies with the fact that you have a lot going on and it's hard to get it all done. So on the other hand, I've got 5 bosses who are telling me to get water rights moving and get rid of the backlog that's existed for decades. And that's why the legislature created my office. So as I think I alluded in some of my prior comments, that's what I'm dealing with. I mean, that the very first time I sat down with Joaquin Esquivel, he said, we have got to get the water right process moving. It's just, I don't know what his exact words were, something to the effect of it's an embarrassment, or the community does not have confidence in our process if we can't move things forward. So that's what I'm dealing with. And I know you all know that. So, so just to be clear though, Mr. O'Brien, that would be the exhibit. Can you also submit the proposed order at the same time you submit the exhibit?
Yes.
Okay. I'm looking at Mr. Cho. I know who's going to be doing most of the work on preparing the proposed order. I've been there before, and obviously he's very qualified. So thank you.
Yes, and that's fine with me, Mr. Lilly. Thanks.
Excuse me?
The proposed timeline that Mr. O'Brien suggested is fine with me as well. Thank you.
Okay. All right. Thank you. So let me just see if we can tweak that a little bit. I'll tell you, right now I have more free time. I have a sort of a block of free time in the second half of July. So, and I was hoping to be able to work on this then. So I'm okay with having the hearing. Let's see, I'm looking the first week in August potentially makes sense, but would it be possible for you to get the exhibits, testimony, and draft proposed order filed by, I'm looking at July 19. Is that reasonable?
Yes, I think we can handle that deadline, Mr. Lilly.
Okay. Oh, and one question, Mr. O'Brien, for Northstar, what is the current status of the CEQA document for these petitions?
We are in the process of issuing an initial study. We anticipate a fairly simple initial study and negative declaration, but certainly something that would be adequate for the board to base its findings on, relating to lack of injury to fish, wildlife, and environmental uses.
Okay. Well, the water board certainly will be a responsible agency here, so you know the drill. Obviously, the lead agency has to take the lead in preparing the document. But with that, what would be Northstar CSD's schedule for approving or certifying the negative declaration?
Mr. Cho and I were just talking about that this morning. I think our tentative schedule would be to approve the negative declaration in early July.
Okay.
We probably wouldn't be through the entire statute of limitations period by the time, certainly by the time of the evidence being submitted, but probably would be close by the time of the proposed hearing, but we probably wouldn't be fully through the statute of limitations.
Oh, and that's fine. I think the water board would like you to be through the statute of limitations before the water board adopts the proposed orders, assuming they do adopt the proposed order that I'll say I prepare or we prepare. But that's going to obviously be another month, 1 to 2 months after the hearing at least. So that's not a problem. I would like to have the approved negative declaration as an exhibit in the record. It's just easier if it can all be there to begin with. I mean, we can certainly leave the record open and add that if we have to, but it's better if we can get that in there. But it sounds like we've got a schedule that will do that. So with that, if you can live with that, I will then specify July 19 as the deadline for submitting a written proposed testimony, exhibits, and a draft proposed order. And then as far as the hearing date, maybe we should just go forward and set one right now. And I'm going to check my office's calendar, but we look pretty good the first 2 weeks in August. I'm thinking of, oh shoot, what would be good? I'm thinking of like August 4th, 5th, or 6th. But if you can bear with me, I'm going to click here, and I sure hope I don't lose you. If I do, I'll come back and just make sure. I mean, the main thing I want to make sure is that we don't have another hearing set, because my staff is really good, but they can't do 2 hearings at once. Yeah, those days look okay. So do you have for Mr. O'Connor, Mr. Taggart, Mr. Bryan, Mr. Cho, all of you, if it's August 4, 5, or 6, and I suspect this hearing will take about, I'll say 2 hours max, probably 1 hour. Seriously, having no opposing parties makes hearings go a lot faster. But is there a preference between August 4, 5, or 6 for all of you?
No preference for us, Mr. Lilly.
Mr. O'Connor, Mr. Taggart?
We don't have a preference, so whatever works best for you, Mr. Lilly, will work for us in there.
Okay. I have a meeting on the 5th, so I'm going to tentatively, unless my staff tells me otherwise after this call, let's plan to do this on August 4, starting at 9 a.m. And obviously it'll be by Zoom, and I'll put 9 to 12. I suspect we can do it a lot quicker than that. I mean, probably an hour is all it will take, but we'll block out the time in case we need it. And and I guess also in case for some odd reason somebody else shows up and decides they want to participate, then I want to make sure we have time to deal with that. So, okay, well, that'll work well. That gives me, let's see, 1, 2, it gives me about 2.5 weeks to review your materials. I think that'll be enough. Yeah. Well, shoot, let me just see if I want to have more time. I do want to be able to read everything. How much stuff do you plan to submit here? How long is it going to take me to read it all?
I don't think it's going to be very voluminous, Mr. Lilly. I know we listed a number of witnesses, but that was frankly out of an abundance of caution. I think we'll have probably one NCSD witness kind of explain the background situation from our viewpoint, and then we'll have one joint engineering witness from Wagner and Bonsignor that'll provide some of the more technical information. I would expect that Trimont would also probably have at least one witness. So, probably 3, maybe 4 witnesses. I don't think we're talking about real extensive written testimony or exhibits here. Probably in the nature of 10 exhibits. Okay.
Well, I think 2+ weeks. Well, I should ask you, Mr. O'Connor, anything you want to add on that?
No, nothing. We have the same plan, Mr. Lilly. 1, maybe 2. pieces of testimony from Trimont witnesses to explain Trimont's side, and then of course the shared witness.
Okay, tell you what, I'm going to just move it to, since you both said it was okay, I'm going to just move it to August 6th, just to give me a couple more days in case I need them. We'll make it August 6th, 9 a.m. to noon, if that's okay. And don't take my comments to mean you should hold back. You know, I mean, don't submit junk that's not relevant, obviously, but if you think it's relevant to support the proposed order, please submit it, and you know, I'll get through it. That's what my job is. And on that note, I did mention the Water Code 844, the regulations 844 factors, which obviously you should cover, because I can guarantee you the board members will scrutinize our proposed order and make sure we have covered those. And then, of course, the big question, which we've mentioned in the hearing notice, is you will need to demonstrate that water is available under the Truckee River Settlement Act and the Truckee River Operating Agreement, because the order clearly will have to cover that, because I mean, I will want to know, and the board members will want to know for sure. I mean, frankly, I'll just tell you, I could not believe we could issue a notice of petitions in the Truckee River Basin and not get any protests, but I guess that's because the amounts that are pretty well settled, how much has been allocated to California and to the Truckee River part of California under the Settlement Act and TROA. So apparently nobody has an objection to that. But anyway, you should make sure that that is set out clearly, those two factors, extension of time and availability of water, because we have to have a proposed order that covers those well to satisfy my concerns and obviously the board members' concerns. So, okay, any comments or questions on that?
Just one question about the hearing procedure, Mr. Lilly. I think you alluded to this, but would it be your plan to submit the written testimony and essentially have the witnesses available for questioning by you or staff, but not really take the time to present the direct testimony?
Correct. I don't think you need to. I mean, normally I ask the parties to prepare summary slides that facilitate their summaries, which, you know, obviously are quite helpful, but I don't think we need any of that for this. So, and hopefully that'll save you a little time. I think as long as you have the written testimony, and of course it'll cross-reference the exhibits you're submitting, that will be sufficient. And of course your proposed order should cite your exhibits as well, which I know you will, but just so we've got all that. But with that, I'll just ask the witnesses to take the oath to confirm that their written testimony is in fact their testimony for the hearing, and then ask clarifying questions. I don't think you need to do any summaries for this.
Thank you. That's helpful.
Yeah, it's different than most of our water board hearings. I mean, for obvious reasons, without opposing parties. So yeah, I think that'll make it go fairly quickly. But yeah, trust that I will have read everything before then, so I won't need the summary. Okay. I think that's all I have for today. Have I missed anything, or is there anything any of the four of you would like to add? No. Okay, and my staff is all on mute, but I'll just give them a chance if I've missed anything regarding scheduling or logistics. Obviously, we'll do this by Zoom. I'll just say, you know, the COVID-19 pandemic has obviously had a lot of challenges for all of us, but one thing that's easier is doing hearings by Zoom as opposed to in person. I think we get better records, and obviously for those of you who do not live and work in the Sacramento area, it means there's a lot less travel time. And also we get a hearing record. I mean, we just use the Zoom recording and put that into the administrative record as our record. It's maybe not quite as easy to follow as a court reporter transcript, but we get it a lot quicker. We get it the next day as opposed to 1 to 2 to 3 months later. So that really does help move our process forward. So, okay. Anything else, or are we done for today? If we are, I'll go ahead and work on that pre-hearing conference order, and we'll go from there.
Trimont
That was
doesn't have
gonna be
any
my question.
questions, Mr. Lilly. We appreciate your time this morning.
All right, thank you.
Same here. Thank you, Mr. Lilly.
Likewise.
Okay.
Thank you.
All right, thank you all. Have a good day, and we'll I'll look for your papers on July 19th, and then we'll talk on August 6th.
Thank you.
Thank
All
you.
right, thank you. Goodbye.
Bye-bye.